Thank you very much. It is indeed a pleasure to hear from all of you. This is quite a daunting audience, quite frankly, the jury has had to appear. I hope I can do some justice with what I want to say. I will speak briefly about some of my experiences and some of the concerns that many of you have and which I share. I won't go into too much detail on the rules and the constitutional provisions because I know my colleague Mr. Case is dealing with some of those. But I'm quite happy to answer any questions that you may have, any concerns that you may wish me to address at the end of my presentation or at the end of this conference. The first thing I'd like to say, several days ago I read in your local media a statement by a government official which was attacking the criticism that's been made of these trials. And the statement was that this government is committed to running these trials. Well, that's a very concerning statement to make, considering it's the courts that should be running these trials, not the government. One of the things that we have to remember is that justice not only needs to be done, it needs to be seen to be done in order for these trials to have any merit in being taken forward. The experience that I have in the field of human rights and war crimes comes predominantly from a period of 8 years that I spent in Bosnia. This is with a national tribunal, very similar to what you're all setting up here. Mr. Cade's experience is slightly different because he's had a lot more experience with the international tribunals than I have. But my experience is setting up a national war crimes tribunal within nationalist laws. And that is a very different problem to cases being set up as international tribunals, as you will experience. They have to be set up within existing or amended national laws, national procedures, and of course they have to be in full compliance with the defence rights that you already have contained within your criminal procedural rules and your constitution. The concern with what's being done with this tribunal is the removal of certain rights, which is of great concern. I started in Bosnia in the year 2003 when many cases at that time were almost exclusively war crimes trials that were being dealt with by the International Criminal Tribunal of Yugoslavia. However, it was considered that the tribunal in The Hague was too far detached from where the crimes occurred, and that those crimes were better served to be prosecuted and adjudicated within the territory where the crimes were committed, so that victims would have greater access to the courts. So the task was set up to establish a war crimes chamber within the existing judicial system. So that's what we did. The difference in Bosnia compared to here in Bangladesh is that we had a great deal of international funds at our disposal. You sadly do not. This is being dealt with by existing resources, and having seen the tribunal today, very scarce resources. And having met with some of the judges today, untrained professionals in this very, very complex area of law. When we established the tribunal in Bosnia, the first thing that we had to do was to ensure that defence counsel, prosecutors and judges were fully trained in this very complex area, because it is very complex. The judges today expressed to us as they have no formal training in war crimes law, international humanitarian law, or any of the procedures that go hand in hand with these types of trials. That is of great concern. My first role in Bosnia was setting up a criminal defence office, and that was to provide a core group of trained lawyers to assist in defending these cases, both national and international. Now, I understand from the rules that foreign counsel are entitled to appear before the tribunal. Whether that in fact has happened is obviously another matter entirely. Foreign counsel as prosecutors can also appear. I then spent about 6 years with the prosecution as head of the War Crimes Unit of prosecution, and encountered a great deal of problems that you will face. Well, I have to say that generally these tribunals are not set up for people to be acquitted. These tribunals are generally set up for successful prosecutions, and obviously for the defence bar, that's a great challenge. And certainly that was the greatest challenge for me as a defence lawyer in ensuring that no matter what is said, protections of the Constitution remain intact, and that there is the right of appeal to a higher court. There is a right to challenge the jurisdiction of the tribunal. There is a right of appeal to the constitutional courts, and then there is a right of appeal to a human rights body, namely the European Court of Human Rights. That is the way that fair trial rights were respected and continue to be respected in these very complex trials. As I said at the outset, justice not only needs to be done, it needs to be seen to be done. And I think that's the most important message that I would like to make today. That is my brief summary of what I've experienced today and some of my experiences in the past. I don't want to bore you with individual cases and a long list of what I was involved in, and I know the other speakers have a more in-depth presentation as to the rules and as to the constitutional protections, whether they exist and to what extent they should continue to exist. So I'd like to thank you very much for the time, and I'm happy to answer any questions you may have.